Welcome one and all to the monthly Landlords virtual meetup. As it says there, we're doing legal update today with Elizabeth and Keith from 33 Bedford Row. Before that, we're just going to have a brief update on the mortgage situation with Jenny from Mortgages for Business. So welcome one and all. With no further ado, Jenny, let's hand over to you just to give us an update on the mortgage situation. We're going to try and do this as a regular thing, although Jenny's going to clear off in August. I don't know why, for goodness sake, but thereafter, hopefully, we're going to make this a regular thing. So, Jenny, the floor is yours.
Thank you. Good afternoon, everybody. So I thought before we launch into the mortgage update, I'll just give you a quick overview on the housing market as we're seeing it right now. And it's been really busy in the housing market of late. So really just some numbers for you just to illustrate. So currently the annual house price inflation is now at its strongest level in nearly 7 years, with the average UK house price now sitting at 261,743, which is a new record high. House prices have increased 9.5% year to date, and that's 2.4% over the last quarter and 1.3% April to May 2021. Now, in terms of what economists are predicting, they are expecting house prices to continue to rise until the end of 21. Beyond this, it's really going to depend on how well the economy performs as we rally from COVID. The rental market also seems to be doing incredibly well. Excuse me, the most recent reports are showing that rental demand and yields are on the increase. I know that some landlords may feel slightly differently about this, but this is what the reporting is telling us. Most notably, central London's letting market has woken up as tenants are starting to return to offices and the hospitality industry. So in December 2020, the average yield in London dropped to 3.8% from 4.2%. It's now recovered to above 5%. The Southwest, Wales and the Northeast have seen really considerable increases in yields, with most of the UK following suit. So really just to give some context around the buy-to-let market more broadly. Now, in terms of the mortgages, this time last year, we had 1,424 buy-to-let products available. We've now got approximately 1,815. Now, during the previous 3 months, the general direction of pricing, the general direction of travel has been downwards. And this is most notably in the specialist arena for limited companies, large portfolio investors, HMOs, multi-units, that kind of part of the market. And what we think is going on there in terms of the pricing coming down is that the purchase market is now really starting to cool off, and the lenders are receiving fewer new mortgage applications. So the lenders are really watching this, watching their inputs drop, and are really starting to think about how they're going to drive business going forwards. And, you know, on the back of that, they're starting to reconsider their pricing. So look, in terms of what we've seen in the mortgage market since I last spoke to you guys, the first thing we've seen is an increase in the number of lenders who are offering 80% loan to value mortgages. Most notably and most recently, the Mortgage Works moved into the 80% space, offering rates from 2.49%. And I think what this really goes to demonstrate is, from a lender's perspective, first of all, an appetite to lend, but also a real confidence in house prices going forwards. When lenders start increasing loan to values up, it definitely shows that they're feeling very confident about what house prices are going to do going forwards. Now, as I mentioned, we've definitely seen a downward trend on pricing, and this is particularly in the specialist end of the market, so HMOs, multi-units and portfolio landlords, and also limited companies. So limited company rates now start from 2.75%, and personal rates 1.19%, so really, really good. We've seen some more lenders move to what we call pay rate calculations on 5-year fixed rates. So what that means is that when they're looking at how much you can borrow per pound of rental income, they're offering you more per pound of rent they would have done previously, assuming you take a 5-year fixed rate. So essentially they're trying to lend you more money. Again, this is lenders revisiting their criteria and trying to give you something more to try and drive up their new business levels. We've also seen some new entrants to the holiday let market. So holiday let rates now start from 2.99%. There's definitely an increase in terms of lenders' interest in this space, invariably driven by the fact it's a real growth market for the time being. Now, in terms of the holiday let offering, there's 2 ways that lenders would look at the affordability. Some use the actual holiday let income that you would receive on the property, and others are using a notional AST rental figure. But the key point here is this market is really growing at the moment, and the pricing has come down not insignificantly, if I'm honest. We've also seen an increase in the number of lenders offering green mortgages. And a green mortgage is where a lender will offer you a preferential rate to their existing product suite because your property meets a benchmark criteria in terms of its energy efficiency. Now, it's a real buzzword in the industry. It's very, very trendy. Lots of people are talking about it. In my personal view, because of the kinds of lenders who are really pioneers and the kind of rates that come with using those lenders, it will often mean that actually if you looked at a green mortgage versus using a lender who was not offering a green mortgage, you may still find that you're better off going to a normal lender and not going for the green mortgage rate. But I think it's really to be applauded that lenders are really starting to support this part of the industry. Some lenders are offering green mortgages if you go to them as a new borrower. Other lenders are offering really good rates if you're doing a further advance to do energy efficient improvements to your property. So that's a growth part of the market. I think we're at the start of a journey on that one still. What else have we seen? We've seen lenders certainly paying more attention to bank statements when they're underwriting the mortgage applications. And the reason for that is if a landlord was to present a lender with their tax returns covering the period to April 2020, what that essentially does is totally miss out the last year and a bit where we've had the real kind of fallout from COVID. So lenders are really looking at bank statements to try and make sure that the income and clients' kind of credit profile has been maintained over the last few months. They can get comfortable that the client isn't in a bad situation, even though a tax return may paint a very different picture. We've also seen bridging loan to values up to 80%. So a lot of the lenders were at 50, 60, 75%, and we're now seeing an increase to 80% from some providers. And again, I think if a bridging lender is willing to go to 80% loan to value, that really is a true indication of expectations on house prices going forwards. Bridging finance is very much asset finance or asset lending. So lenders are really purely hanging their hat on the property price holding firm or going up. So an increased loan to value in bridging finance is always a good sign of what people are expecting to come. And the other thing I really just wanted to share with you is we've seen a new refurb to let option come out, this time from Paragon. So a refurb to let mortgage is where you have a bridging loan and a pre-underwritten exit mortgage, which is all agreed at the same time up front. For our clients who are looking to take on properties which need work doing to them, they seem to really like these products because it allows you the ability to buy the property, but also a guaranteed exit post-works where you can mortgage onto up to 75% of the end value of the property. Now, previously, Precise Mortgages were the lender offering sort of the best of these products, but the bridging finance element of the deal was at 65%, whereas Paragon are offering it at 75% of purchase price and then 75% of market value post works. So a really, really solid offering, which our clients are really, they're quite excited about actually. And that is the whistle stop tour of mortgages for the last couple of months. It's been really busy. It's always busy, but I hope you found that really helpful.
Right, well, thank you very much for that, Jenny. So we've got no questions on the chat, so I don't know if anyone's got any questions. Are you hanging around for a while, or
I can stay on, absolutely. I'd love
okay.
to.
Okay, well, hang around for a while, and we'll see if we do get any questions or whatever. And as I said to everybody when we started this, although we've had a few people join again since, we're hoping to make this a monthly thing. I'm going to stop Jenny going away in August, so she can't go away. So, but no, that's very useful. Thank you so much for that.
Thank you.
Okay, right now we're going to hand over to Elizabeth and to Keith. I don't know who's going to kick this off, but Keith, I think you're going to share your screen with the slides, aren't you? So if you want to give it a go,
I'll just do
there you go.
Right, can you see that?
Yeah, we can do. Yeah, we're fine on that.
I'll just full screen that. There we go.
Yeah, that's fine. Thanks.
Perfect. So just by way of introduction, my name is Elizabeth Fisher and this is Keith Plato, and we are both barristers at 33 Bedford Row. We both have mixed civil and commercial practices with a particular emphasis on property and housing law, and we also practice in insolvency because there tends to be quite an overlap, unfortunately, between the two areas. So today we're going to be talking to you about landlord and tenant possession proceedings, and also the new breathing space provisions which have been introduced. In terms of the possession proceedings, we will be giving an overview of Section 8 notices and the steps required, the impact of COVID, and providing updates on the notice period, as well as highlighting things to look out for. So the general legal framework, I'm not going to go into too much detail on this point because it may be quite boring, but essentially these are the key provisions which regulate possession proceedings. So any claim that's brought before the courts is going to be under what's called CPR 55, and that gives the framework for possession. And there have been what most people will be familiar with is the Housing Act or the Rent Act, and they will give the grounds or the ability to be able to seek recovery of a property that has been left out, so for you to seek possession. So the focus of this talk today will be on ASTs, as that tends to be the most common type of tenancy agreement which is used. So if we go to the next slide, please, Keith. So ending an AST during the tenancy, this is most commonly when arrears have occurred. So usually you would be relying on ground 8, as that's the mandatory ground for possession, but you may also rely on grounds 10 and 11, which provide the court with a discretion, and under those grounds you're saying that there is some arrears and that there is a late payment of rent. Other key grounds which are relevant during the operation of a tenancy would be ground 7, which relates to antisocial behaviour, and ground 7A, which may not have come up too frequently, but it's specific provisions for domestic abuse and domestic violence. So that when you want to seek recovery or possession of your property, you must first serve a notice, and for a Section 8 notice, it's in a prescribed form. So it's very important that you use that prescribed form. Now, I'm sure that some of you, I hope, or most of you have been on the iHouse website, so you would have seen that there are a number of templates and pro formas and guidance which will take you through Section 8 notices. But it's quite straightforward. If you don't find it on the iHouse website, or you don't use the advice line, you can always go on Google to be able to find the specific notice. Now, the notice must be served on the tenant, and there is a set period for which that notice before it expires. And those notice periods are what there has been much change in respect of regarding the past year. So if we move on to the next slide, please, Keith. There was an announcement on the 12th of May which changed the basic notice periods and reduced the notice periods from 6 months to 4 months. So back in March, on 26th of March 2020, all notice periods were increased to 6 months. This, of course, caused numerous issues for landlords, particularly if rent arrears were accruing, as it meant you had to wait half a year before you could issue proceedings. Additionally, if you had tenants who were behaving antisocially, you also would have to wait. So in a moment, we'll go through the different stages of the variations of the notice periods. That's essentially on the 12th of May, it was stated that the 6 months would be reduced to 4 months with effect from the 1st of June. There was also a ban on evictions, and that was said to end. It must end on the 31st of May 2021. But there is a caveat to that, and that caveat is that bailiffs have been asked not to carry out residential evictions after the restrictions are lifted. And if anyone living in the property has COVID symptoms or is self-isolating, then they shouldn't carry out the eviction. So this, I imagine, is going to present itself with some difficulties, because I've seen with court proceedings that people haven't come to court on the basis that they have COVID symptoms. And it's very difficult to prove that you have COVID symptoms because you can't go to the GP for it. You can't get a letter from your GP to verify that you have COVID symptoms. It's essentially self-certifying. So it may be, and this is purely speculative, but it may be that tenants will rely on this provision to prevent a bailiff from executing a warrant on the basis that they have COVID symptoms or that they're self-isolating. Self-isolating is probably going to be a bit easier to prove because usually you'll have received a text message from the NHS, but it will be interesting to see what problems this presents and whether or not there will still be an application to stay a warrant, of whether it's necessary to apply to stay the warrant or whether it's simply sufficient to set out that you have COVID symptoms and what will happen in those circumstances. It's likely that any issues with that is only going to be for a short period of time. I think it's very unlikely that a tenant will be able to rely on this on more than one occasion. But in the same light, there's nothing to prevent them from doing so. So we will see what happens. And then the final point on this slide here is in respect of the white paper. So it was announced that there's going to be a white paper in autumn, which will include a number of proposals relating to rented accommodation. So that will be quite interesting, and when we get to that. But in particular, there will be proposals regarding getting rid of Section 21 notices and no false evictions. So that's something that's always been spoken about and whispered and rumoured, but it's actually now going to be included within the white paper. So it seems that it's going to be more likely that it's going to come to fruition. So they were the key points from the update, from the announcement. And then in terms of those, the update itself, they also stated that the relevant period, so this is for how long the notice periods were going to last, and the extended period was going to be increased to the 30th of September 2021. If anybody's been following the updates regarding the relevant period, you would notice that the relevant period keeps getting pushed back. I think when it first came, it was introduced on the 26th of March. The original date for it to end was 30th of September 2020. So now we're over a year after that. As I've already mentioned, the residential possession notices will be reduced from 6 months to 4 months, unless there is a specific exemption which applies. And those exceptions are antisocial behaviour, domestic abuse, if a tenancy has been acquired by a false statement, rent arrears, or the tenants, there is a problem with the tenant's right to rent, or the death of the tenant. So these are the exceptions for which there could be an even shorter notice period. And now, hopefully, this slide should contain a neat little table which summarises the notice periods for the most common ground, or the grounds at which will be relied on. So we can see here, and this was before the 26th of March 2020. So this was before COVID, when everything was all fine. These were the notice periods that you would rely on if you were issuing possession proceedings. So under ground 8, which is the most common for rent arrears, it would have been 2 weeks. Between the 26th of March and the 28th of August 2020, if a notice was issued during that period, it was increased to 3 months. It was then increased again to 6 months if there were less than 6 months rent arrears. And now from the 1st of June 2021, so this is the most relevant column here because this is the changes going forward. So if it's a new notice which is going to be issued, then there are new rules which apply. So if there are less than 4 months arrears, then there needs to be 4 months notice. If there are more than 4 months arrears, then it's only necessary to give 4 weeks notice. And there will be a further reduction in the notice period from the 1st of August, where if there are 2 months, where you'll only need to give 2 months notice for rent arrears that are less than 4 months, as long as you're relying on grounds 8, 10 or 11. So essentially for the next 2 months, it will be 4 months, and then that will reduce to 2 months. So it's good news if you do have tenants who are in arrears. You will, in all likelihood, still be required to set out what steps you've taken, whether they have been impacted by coronavirus, what discussions you've had with the tenant. But ultimately, if you're relying on ground 8 in particular, it's a mandatory ground for possession. So as long as you have complied with the rules in terms of the service of your notice, and you have the requisite amount of arrears at the time of the notice and at the time of the hearing, you would be entitled to possession. So whilst the COVID factors will be relevant to the court and they will want to know about them, it won't be a bar to possession. However, if you were relying solely on grounds 10 and 11, it may be that the court would exercise their discretion to not to make a possession order on the basis of coronavirus factors. So if we could go to the next slide, please, Keith. So here is the details regarding Section 21 notices. So there was a stay on all Section 21 notices, but this is now, it was lifted last year. But between the 29th of August 2020 and the 31st of May this year, you must give at least 6 months notice. And once you have issued your notice or served your notice, that notice would only be valid for 10 months from the date that it was given to the tenant, or 4 months from the date specified in the notice. So that would mean that you have to act on the notice and issue your possession proceedings within 10 months or 4 months of that date. Now, moving forward, if you serve a Section 21 notice after the 1st of June 2021, then you must give at least 4 months notice, and this will only be valid for 8 months from the date or 4 months from the date specified. So, thank you. I thought I would quickly set out here some of the Section 21 is the one which is more prescriptive, and there are more hoops that you must jump through if you are looking to seek possession under Section 21. So you cannot apply, well, you would not be able to secure a possession order under Section 21 if any of the following on this slide is applicable. So if the tenancy was less than 4 months old, you wouldn't be able to acquire possession under Section 21. If the property is a HMO, so a house multiple occupation, and required a licence either under Part 2 or Part 5, and that licence had not been, Part 2 or Part 3, sorry, and that licence had not been obtained, then you wouldn't be able to rely on Section 21 to obtain possession, unless the temporary exemption applies. So that means where you've applied for a licence. But if you're in that circumstance, you may want to be looking for some legal advice just to ensure, because it can be quite costly to issue possession proceedings and then for it to all go wrong because you haven't followed the requirements. The other three provisions for which you wouldn't be able to seek possession under Section 21 is that if the tenancy was granted on or after the 6th of April 2007, or it was a statutory periodic tenancy that arose after that date, and the deposit protection legislation had not been complied with. So I'm sure everybody's come across the deposit protection legislation now, and the difficulties that can be, not only is the fact that the tenant could be entitled to compensation of up to 3 times the amount of the deposit, but it also does preclude you, and it is a total defence to issuing a possession proceedings under Section 21 if the deposit is not protected. There's also, if the council has served an improvement notice or an emergency remedial notice in the last 6 months, and finally, if you have not given a copy of the EPC gas safety record and the government's house for rent guide to the tenant at the time that the tenancy was undertaken. That's only applicable for tenancies on or after the 1st of October 2015. But if any of these are applicable, then you won't be able to seek possession under Section 21, and you should consider other routes. And now I will hand over to Keith, because we have moved on to the new breathing space regulations.
Thank you, Elizabeth. If I can just check to make sure everyone can hear me okay? Yes?
Yeah, we're fine, Keith. You
Okay,
crack
all
on.
right, excellent. Yep. All right, thank you. So as mentioned, the breathing space regulations, which I've set out in the slide, came into force on the 4th of May 2021. Now, before I go into too much detail in relation to this, there's some guidance that has been issued, which is on the Gov UK website, And it includes guidance for creditors, which will obviously be relevant in terms of for landlords, but there's also guidance for the advisors as well. Now, in terms of what I'm going to cover the types of moratoriums that the regulations provide, the eligibility criteria, as well as what the qualifying debts are, what a moratorium debt actually is, and then the landlord's obligations as well as their restrictions during the moratorium, and then the consequences of a breach of any of those obligations or restrictions, and the challenges that are available to a landlord. Now, it's worth highlighting that the regulations apply to creditors, but obviously modified this for landlords, as they'll count as creditors in any event. Now, in terms of the legislation itself, the basis of it is to provide a moratorium for people in debt, to give them an opportunity to try to address that. Now, there are two types of moratorium. One is the breathing space, where there's simply debt in place and they're unable to pay. And the second one is where a person is the mental health crisis treatment moratorium, whereby the debtor is receiving treatment during that period. Now, as you note, the breathing space regulations last up to 60 days, and there's a midway review that's available once that's started. Now, one of the key features of this is that a debtor is required to pay their ongoing liabilities during the moratorium. So in terms of landlords, any rent that becomes due, the debtor has to continue paying that. Now, the breathing space moratorium is probably going to be the most relevant to landlords, as I imagine that's the one they are most likely to come across, at least most frequently in relation to that. But in terms of the mental health crisis moratorium, the key differences are that this lasts up to 30 days after the debtor stops receiving the treatment, and also that other individuals can apply on behalf of the debtor. Now, a key note at this point is to highlight that these moratoriums can only be started by a debt advice provider who is regulated by the FCA, or alternatively by the local authority. Now, the eligibility criteria is set out in Regulation 24, and I've set out some of the eligibility criteria in there. Now, one of the key things is that the debtor has to owe a qualifying debt and also not have had a breathing space moratorium in the previous 12 months. Now, this is where the difference with the mental health crisis moratorium, because there is no limit as to the amount of moratoriums you can have under that regulation. Now, what is a qualifying debt that's required by the eligibility criteria? The definition is essentially that it's any debt that's not excluded by the regulations. Now, the debts that are excluded include student loans, child maintenance loans. So therefore, anything that's not included, for example, rent arrears or mortgage arrears, can all be a qualifying debt. There is no financial limit on the size of the debt, so there is no minimum limit or maximum limit. And also the debts can have accrued before the 4th of May 2021, which is the date when these regulations came into force. So essentially, if there are rent arrears that have accrued over the last 6 months, these can all form part of the qualifying debt. Now, in terms of the moratorium debt, this is defined by Regulation 6. And essentially, it's any qualifying debt that's owed by the debtor at the time the moratorium is applied for, and the debtor has given those details to the insolvency service. So in the case, again, for rent arrears, any rent arrears that are owed at the time the debtor applies for the moratorium, then that will be a qualifying debt and subsequently become a moratorium debt. Now, one thing to note is that the obligation restrictions we are going to look at only apply to moratorium debts. So for any ongoing rent that accrues after the moratorium started, that will not be a moratorium debt. And therefore, the obligations and restrictions, which I'm going to touch upon shortly, wouldn't apply to anything that accrues thereafter. Now, the obligations a landlord has under the regulations. Now, these essentially kick in once the landlord has received notification from the insolvency service that a debtor, that a moratorium has been registered. At that point in time, the landlord must, as soon as reasonably practicable, carry out a reasonable search of their records for debts owed to them by the debtor. Now, if as a result of that search, it turns out that there are additional debts than those that have been disclosed to the debt advice provider, then the landlord has to notify the debt advice provider again as soon as reasonably practicable. If it's a case that the debt has been assigned, the information has to be passed to the assignee and provide the assignee's details to the debt advice provider again as soon as reasonably practicable. Now, this is important in that if the landlord is an agent, so for example, a managing agent, or alternatively solicitors instructed, it is the landlord's responsibility to notify the agent of any moratorium and the effect of it as soon as reasonably practicable. So if the agent was to then not be aware and take any steps that are not allowed under the regulations, the landlord would obviously be liable as a result of that. Now, if there are existing proceedings, it's also for the landlord to notify the court or tribunal in writing in relation to that. Now, the actual restrictions in terms of the matters the landlord is not allowed to do under the moratorium. You're not allowed to charge interest, fees, or penalties during the moratorium, and also not allowed to take enforcement action without permission of the court. Now, enforcement action is described fairly widely, and this would include any steps to collect the debt, such as sending any debt recovery letters, a statutory demand, a bankruptcy petition, or generally any communication about the moratorium debt are not going to be allowed during the moratorium. The one exception in relation to the communication about the debt is if the debtor actually requests this. So it's advisable for any landlords during the moratorium period to avoid, if they can, any communications with the debtor, as it may be seen as trying to coerce one way or the other payment out of them. Regardless of that, though, the landlord is free to accept any payment for any of the moratorium debts during that period, if it's offered by the debtor. Now, a landlord also can't serve a Section 8 notice on the rent arrear grounds, 8, 10, and 11, during the moratorium period. But in addition to that, if there was a Section 8 notice served prior to the moratorium, based on rent arrears, which are part of the moratorium debt, then you can also not commence proceedings during the moratorium period as well. Now, as I've mentioned previously, if rent that is due isn't paid, and arrears accumulate after the moratorium period has started, then it doesn't form part of the moratorium debt and the protections don't apply. So it may be a case that from the moment the moratorium period starts, new rent arrears accumulate, and the landlord would then be free to either serve a Section 8 notice or start money claims in the court if they wish to do so. Now, the other thing to note in relation to this point is that in relation to Section 21 proceedings, to Section 21 notice, if proceedings are started under the accelerated procedure, then they are not caught by the regulations. So landlords are still free to either serve a Section 21 notice and or commence accelerated procedure proceedings in relation to the tenancy. What is not clear, however, is if Section 28 notice is served and possession are commenced, also seeking to recover the moratorium debt, whether the court would proceed to make a possession order, be able to enforce the possession order, but simply not be able to enforce the money claim. I imagine, given the basis of the legislation, most judges, especially district judges or deputy district judges, would probably be very reluctant to award possession proceedings, even under Section 21, if there's also a claim for rent arrears as well. Now, if proceedings have been issued already, then any proceedings, as long as they are not a bankruptcy petition, can actually continue. So that means any money claim that's issued prior can continue all the way to judgment or an order is made. However, if, for example, there is a money claim that's undefended, the landlord cannot apply for default judgment. So it provides a situation whereby if a money claim is started and is defended, you can potentially go all the way to trial and have an order made. Whereas if it's undefended, and then during that moratorium, essentially nothing can be done until the end of the moratorium period. Again, cannot enforce a judgment. So for example, cannot apply for a warrant or writ. And the Gov guidance highlights that any enforcement hearings, so for example, an application to stay a warrant, should not be heard during the moratorium period. So it is likely that if there was an application previously and it was listed during the moratorium period, it is likely that hearing will be adjourned until after the moratorium ends. Now, in relation to joint tenants, if they are joint tenants, the position is that as long as one of the tenants has got a moratorium in place, then all the joint tenants get the benefit of these protections. So that essentially means as long as one of them gets it, you cannot enforce or seek to enforce a judgment or recover the money against all the joint tenants. In terms of guarantors, it's slightly different. The guarantors are not covered, and a guarantor would have to apply for their own separate moratorium as they are individual in order to get protection under the regulations. So you can have a position where the tenant is protected under the moratorium, but you are able to pursue the guarantor separately during that moratorium period. The only thing to bear in mind is, again, if there are multiple guarantors, but one guarantor applies and gets the benefit of the moratorium, then it's obviously going to cover all the guarantors similar to, it will be similar to the joint tenants situation. Now, if there is a breach by a landlord, it's fairly straightforward. Any action taken shall be null and void. So, for example, any Section 8 notice will have no effect, and any proceedings commenced during the moratorium period are likely to be struck out, and obviously likely to be consequences as a result of that as well. Now, the one thing that's not entirely clear is in relation to the if there is communication about the moratorium debt. It appears what is from the guidance that what is likely to happen is you'll get a letter simply reminding you not to communicate with the debtor during that period. The other thing, just to mention in terms of the breaches as well, is the positive obligations when the landlord has notification of the moratorium. So, for example, not notifying the debt advice provider as soon as reasonable practicable of any assignee or any of those other matters we've discussed, is that the landlord may be held liable for any losses that might be incurred by either the debtor or any other creditor. Now, what challenges are available to the landlord? Well, a landlord can request a review to cancel the moratorium. There are two grounds in which this can be done. The first is if it unfairly prejudices the interests of the creditor. And the second, if there has been some material irregularity. Now, in relation to the irregularity, there are only three grounds which there can be irregularity. So one is in relation to the eligibility criteria. The second is if it's not a qualifying debt. And the third is an argument that the debtor actually has sufficient funds to meet his debts. So those are the only grounds by which a landlord can challenge the moratorium a debtor has in place. And in order to do so, the landlord has 20 days to do so from the start date of the moratorium, which the landlord will be notified by the insolvency service as well. Now, if the landlord is not successful in relation to that review, there is essentially an appeal process in which you can apply to the county court, and you'd have to persuade the county court that the grounds which you've already mentioned actually apply. Alternatively, you can seek for permission to take enforcement action against the debtor, despite the moratorium. This will only be allowed where the court deems it's reasonable to allow the creditor to take whatever relevant step they wish to take, and it is not detrimental to the debtor, or alternatively, does not significantly undermine the protections. Now, it's difficult to see how allowing enforcement action may not be detrimental to the debtor, because essentially it's taking away the very protection that the regulations are meant to provide. And similarly, it appears it will significantly undermine the protections in the regulations. So it's not clear when the courts will exercise the discretion, but I imagine it's going to be in rare cases. One example that has been floated around is an example where they are joint tenants. So joint tenant number one applies for the moratorium. And as a result of that, tenant number two has the benefit of the protection. However, if the second tenant owes, let's say, 90% of the debt, it might be a situation where you apply to take enforcement action against the tenant two on the basis that he owes this more significant amount of money. If he's able to meet his debts, so there's no reason for him to be able to have that protection. That seems perhaps potentially a way to apply to take permission for permission to take enforcement action in those circumstances. Now, if there is no challenge by the landlord, the breathing space regulation would end, as I mentioned, up to 60 days after the start. Or alternatively, if it's the mental health crisis moratorium, then that will be 30 days after the end of the treatment. Both of them will also end if the debtor dies as well, or they are cancelled for any other reason. So in just summing up the brief outlook, essentially as a landlord, you'll get notification when the moratorium is registered, as the insolvency service is going to keep a record of when moratoriums are registered. As soon as you have that notification, you need to comply with the obligations as soon as reasonably practicable. And as soon as that happens, ensure you don't infringe any of the restrictions. And I imagine the one that's likely to happen by mistake is most likely the communicating with the debtor about the moratorium debt. And then when the moratorium ends, you also get a notification again from the insolvency service to let you know of that information. Now, that's everything for me. I don't know if there are any questions at all.
Yeah, we've got some questions. Thank you for that, Keith. It's all good stuff. We've got one come up on the chat. I've got a few things just before we go on. Hopefully, we'll get a few more on the chat. On the breathing space, are you aware of any cases at the moment? It came in May the 4th, didn't it? So, is it still too early to know whether anything's happening with it?
Yeah, still too early. I had a possession case probably about 3 weeks ago, where the debtor, the defendant, was receiving mental health treatment. So it was expected that a mental health crisis moratorium was going to be applied for in that case. But I don't know whether that has been done as of yet. It's still fairly new, and I think even the advisors are still getting used to it and knowing when to use it at the time.
I think it's worth pointing out to people, reminding people that if it's a mental health moratorium, it can go on for a very long time. So
yes,
yeah,
it's until the treatment ends, essentially.
Yes,
so,
yeah, plus 30
however
days.
Long, yes, however long that takes.
Which could be years. But I mean,
yes.
to be fair, if you had I mean, we are talking with someone in old-fashioned parlance that's been sectioned. So you know, it's something that's pretty unusual, I would have thought. And to be honest with you, I would have thought that if you're dealing with someone that lacks the capacity to understand anyway, it's always been a problem.
Yes, I think this is probably the only, I guess, legislation allowing how to deal with that situation more than anything else.
Yes, because I know I went to a talk several years ago now by a firm of barristers somewhere, I don't know where they were, somewhere in Southampton, and they were talking about people who lack the capacity to understand what's being said to them for whatever reason. And their basic point was that this is very specialist. You know, do not get involved yourself.
Yes, I think before these regulations, you would have to show there is a lack of capacity altogether, which is obviously a higher hurdle. Whereas in terms of as long as they are receiving some sort of mental health crisis treatment, they may be able to understand, they might have capacity in the legal sense, but it doesn't necessarily mean they're able to then deal with the matters as and when they arise at that point in time. So it probably bridges those two a little bit more than anything else.
Okay, well, thank you for that. Right, we've got a question coming on antisocial behaviour. I don't know if you want to take it or Elizabeth wants to take it. So from Chris, thank you, Chris. Basically saying he's done a Section 8 with Ground 7 and Ground 8 on the basis that it's more or less immediate. I know David Smith, our solicitor friend, is very keen on doing Ground 14 with a Grounds 8, 10 and 11 on the basis it hurries the whole thing up. But really, Chris's point is if he's going with antisocial behaviour as well as rent arrears, and at the time of the court hearing, the antisocial behaviour case is weak, how does that affect the rent arrears case? So I don't know which one of you two wants to take that.
I will take this if that's okay, and then Keith.
Thank you very much.
Miss anything out. So in terms of being able to secure a possession order under Section 8 or Ground 8, you would need the notice period itself has to have expired. So you would still have had to have complied with 4 months' notice before possession proceedings were issued. So you couldn't serve both notices, then issue under your Ground 7 and, well, I'm guessing 7A and social behaviour, and issue for your Ground 8 until your Ground 8 notice has expired. So even if you issued under Ground 7 to begin with, and then by the time you got to your court hearing, your Ground 8 your Section 8 notice had expired, so you could issue under that, you wouldn't be able to amend your possession proceedings. It's most likely, or it's very unlikely you'd get permission to amend. You would then have to start your possession proceedings under Ground 8, because the notes within the notice itself are quite specific in that it says the court proceedings will not begin until after a certain date. So you can't use Ground 7 as a way of being able to bypass the notice period, essentially.
Okay, that's interesting you say that, because I've heard David Smith do talks on this, and he's been suggesting that if you do, say, a Ground 8, 10, 11, for the sake of argument, and also a Ground 14, then the Ground 14 trumps the rest. You're saying that's not the case, so that's interesting.
No, sorry, I mean, it would be, but if you got to court and you had issued under your Ground 8, your Ground 14, and your Ground 8 notice hadn't reached the expiry yet, you couldn't then just fall back on your Ground 8 proceedings. You'd have to wait for that notice to expire. So you can't make that, you can't shorten that period by issuing under another ground with a shorter period.
Okay, gotcha. So in other words, if you went Grounds 8 and Ground 14, say for the sake of argument, and you went to court after a couple of days and Ground 14 was proven, then you'd be fine. But
yes, exactly. It's the same as pre-COVID, when people used to issue for Ground 8, would do a Section 8 notice and a Section 21 notice. And then if either of them failed, you'd rely on the other one as sort of a backup, but you still have to meet the requirements for both. And in terms of Ground 8, that means the requisite notice period.
Okay, I've got a couple of other questions coming. We'll go on to those in a minute. One interesting thing you said about Section 21, Section 8, etc. A lot of people will issue a Section 21 for antisocial behaviour because it's just difficult to prove, and in particular, especially where you get HMOs or the antisocial behaviours against a neighbour or something like that. It's very, very difficult to get witness statements. So have you ever been successful with a Section 8 with antisocial behaviour, or have you just gone for Section 21 and had done with it?
I've always, in those circumstances where I've been for a landlord, it's always been Section 21. Antisocial behaviour can be quite costly for a landlord in terms of issuing proceedings. It tends to be an argument that's more run by housing authorities and local housing associations and local authorities, as opposed to private landlords, because in all likelihood it will require a trial, and that will usually last at least a day and will require evidence of different parties, and that can be quite expensive and costly. So whilst you have the route available to you of Section 21, which you can go down the accelerated procedure, and you can do that as long as you've met all of those requirements that we went through earlier, that can be a quicker and cheaper alternative.
Okay, all right, thank you very much. I don't know if Keith, if you'd be able to see the chat box. So we've got a couple of questions on the moratorium. So I think you've already answered one, which is, there's a joint tenancy and one tenant applies for a moratorium. Does this apply to the joint and several liability, he's put singly, and joint and several liability rule on the other tenants? I think you've already answered that one, haven't you? So
yes, yeah. So as long as one tenant has got the benefit of the moratorium, it means all the joint tenants
Yeah.
also have benefit of the
It's a bit of
moratorium
an
as well.
oddity, really, I find. So, put it
Yes.
mildly. So,
Yes.
anyway, right. The other question we've got coming is, with respect to the breathing space regulations, can Keith please confirm that failure to pay the reserved rent will mean that the landlord can take the necessary steps to end the tenancy?
No, I'm not sure what you mean by the reserved rent, but essentially, if the rent arrears form part of the moratorium
Yeah.
debt, then during the moratorium period, you can't. But if there are new rent arrears that are accrued after the moratorium period starts, then those rent arrears are not part of the moratorium debt. So you can then take steps on those rent arrears.
Yeah, so that's an
tenancy.
important point to realise, which is that if you apply for a moratorium today, what is it? It's the 5th today.
Yeah.
It applies to all arrears as at the 5th, but any
That's right.
new arrears after the 6th going forward, the tenant's still liable for and still liable to pay the rent as well, unless
Yes.
it's a breathing space moratorium.
Yes, that's right. I think the one thing that I'll highlight as well is because of the mid-review, what tends to happen, what is expected to happen, is that the debt advice providers, the requirements will be for the debtors to continue paying the ongoing liabilities anyway. So they may cancel the moratorium anyway for failure to pay those debts in any event.
Okay. I don't quite understand what you mean by the reserved rent. Is that a legal word, reserved rent, or is that one that Bash has made up? Bash, you're making up words again. Okay, right. This may be for Elizabeth, this one from Chris again. If the tenant moved in as a joint and several liable tenants, but the AST contract was done wrong, would the judge look to see what happened on the grounds and ignore the agreement? So I don't know which one.
I would say that seems quite fact specific. So it depends on what is wrong with the AST. Usually, I mean, yeah, I don't know what could be wrong with the AST to make it wrong, because essentially, even if there's a contract between the parties, because you can have ASTs without a written agreement. You can have an oral AST in terms of a tenant living in a property, they're paying rent. So I can't see what would specifically be categorised as wrong. I can see Chris has got his hand up.
Chris, do you want to come on and expand on that a bit? Nope.
I think you're on mute, Chris. I'm not sure if we have the capacity to unmute you.
I don't know.
I'm on mute. Right, I'm unmuted. Thank you for that. So thank you, Elizabeth. So very briefly, tenants came in and under an AST contract. My manager got it wrong. First of all, he only put one of the names down, and then subsequently didn't put the other name down to a month later. But on the ground, they both moved in together. So would the judge look at what happened on the ground? Would they look at the AST contract?
It's difficult. It's quite because each judge is different, and without seeing the agreement, it's difficult for me to advise you on that. But on the whole, I think the court would take a global look at things. I think with issues like that, it's often better to be upfront about it and set it out in your particulars of claim to say that the hold tenancy doesn't necessarily reflect the true circumstance. I think if it was a case that was come before me, there would be a lot more questions that I would be asking, such as who paid the rent, who do they pay it to, deposits. I think it's quite a niche question for me to be able to offer you advice on over this. I've seen that Keith's come off mute, so maybe he's got something else to add in those circumstances.
Okay.
The only thing I was going to add is, as Liz highlighted earlier on, you don't have to rely on the written contract. So if your case is that there was a verbal agreement or by conduct thereafter, that's what you can rely on. The AST doesn't have to be in writing. So it's essentially a matter of what basis you say they are both liable. So if there was a verbal agreement or by conduct or something along those lines, you can simply rely on that rather than the written contract as well.
But I would stress, wherever possible, try to get everything in writing, and
Of course.
I'm amazed. I don't know how often you find it. I'm amazed how often on our helpline we get oral agreements.
Yes.
You would imagine it'd be a real rarity, but it comes up. It's not too infrequent, and it tends to be where it's between friends or relations, or oh, he's only going to be there a month or two, sort of thing.
Yes.
And we all say to people, no matter what, no matter who, always get a written agreement. Otherwise, you can have all sorts of argy-bargy afterwards.
Yes.
And,
Yes.
and who earns from that? Legal people.
Can I just add another problem I've seen in my AST contract? We date everything from the 1st of the month, and they didn't move into the 7th of the month. So I'm assuming, Elizabeth, what you just said, that the judge will say, give evidence as to when they moved in. And the reason why this is important is that the right to rent, the gas certificate, and the energy performance certificate wasn't actually given to them until the 4th of the month. And even though the contract said the 1st, and they only moved in on the 7th of the month. Would that be acceptable, or is that going to be a big problem?
It depends on the judge that you come before, because I know that there's been an update to the case on the gas safety, but there's a Clarendon Properties case where the gas safety wasn't given prior to the start of the tenancy, and then his Honour Judge Lou QC said that precluded a Section 21 notice from ever being served because it's not sufficient to give the gas safety after. So I think in those circumstances, it's better to have the start date of the tenancy as being the actual start date of the tenancy, as opposed to just putting the 1st of the month, because I guess there's no real benefit to having just stated that it's the 1st of the month. And then it will be for you to because essentially you would be arguing that the written agreement that you've got doesn't reflect the reality of the situation. And then the question is, why did you enter into that agreement in the first place?
We've also got a question coming: are verbal agreements ever held up in courts?
Yes, because often they, as Peter's already referred to, a lot of tenancy agreements are unfortunately dealt with as a verbal agreement between the parties. It tends to make things a little bit more messy because you need more evidence from the parties as to what they say are the terms of the agreement, how it became established. But ultimately, if somebody is living in a property, it's likely that they would be paying rent for it. And if they're not paying rent for it, they can't be there under an AST, so they would be there under some other basis. So often with property matters, the facts kind of speak for themselves because they must be there for a reason.
Yeah, so I think it's worth stating to people that if a tenant can prove they're paying rent and the landlord's receiving it, and normally, unless it's a resident landlord, something like that, then an AST is in place.
Yes, on the whole.
Yeah, I mean, there are a few exceptions, but generally it's very rare, isn't it? Well, look, we're getting towards the end. I just want to rattle through a few points that came out of that. I think we've proved that whereas before March of last year, it wasn't overly complicated to do your own Section 21 and Section 8. The recommendation is don't do it yourself at the moment. It's just got so complicated, but things keep moving around. You don't want to do fill out a form, wait a year, which could happen, and then get to court and find that it's just all thrown out. You've got to start again. So do get specialist advice at the moment. I know there's been cases recently of this thing that Elizabeth was mentioning with COVID, where tenants have been in place, won't go to court, etc., because they're saying they're having to self-isolate or whatever. So this is one. It's going to be one. I think it's going to be interesting on this one. See what comes out with that one. Elizabeth also mentioned the white paper, which is due to come out towards the end of the year. I House are definitely trying to have some input into that. So any comments are gratefully received on that one. False statement was mentioned, also the right to rent. that there was a bit of a change there. I don't know if you want to comment on this one, Elizabeth, but happened on July the 1st with EU citizens. If you've got an EU citizen who were in before July the 1st, you're absolutely fine continuing with them, but be aware if they've not done their apply for their settlement, then if they lose their job or whatever, they almost certainly will not be able to get benefits. So that's a big change there. So if you've got an EU citizen and they've not applied for settlement, you could have problems in the future. Elizabeth, have you come across this one at all? I know it's very, very new, isn't it? So
I haven't come across it yet, but like you say, it is very new. So only came in from the 1st of July. So I think it's likely to rear its head in the future.
And we're told that things should be going back to normal after October.
Yep, that's what we're told. But we've been told a lot over the last year or so, haven't we? So we'll see how that goes.
Yeah. All right. Okay. And then the last one I want to make a comment on is that Elizabeth mentioned making a false statement. We always recommend that you get an application form filled out. You can get one off the website. That's how you can prove that a false statement's been made, and that's taken seriously. Look, we've gone over the hour. Thank you so much to Elizabeth up on the screen at the moment, Keith and Jenny for everything we've done there. So would you, well, okay, someone's mentioning here, yes, accreditation, where we've got a foundation course coming up, and I'm just trying to look at the date, on July the 20th. Thank you for that, Rodney, for reminding me. That we've got a foundation course coming up on July the 20th, a Tuesday, where we'll take people through all of this. It's a whole one-day course. Trust me, there's a lot to know. Also, trust me, I've been doing this for several years. I've had people along on those courses where they've had 30 years experience. I know everything. You will learn something. You really will learn something. It's changing so often. So thank you very much to all of you. Very, very useful. We have recorded this. I will send it out to you as soon as I can get it sorted out. Rodney's also remind me, Derek is also doing some charity work for Moorfield. I will send that out with information as well. So hopefully see you all again in the future. Last time. Thank you all of you. So thank you very much.